diligently for a number of years. She wrote quite widely on the subject. And I'm grateful that you've asked for you present some comments. I think we're all here as we do not want to repeat the unfair trials that took place at the International Crime Tribunal in the past. We want to hold trials that will not be questioned as unfair or partisan, both domestically and internationally, and we want trials that the country can be proud of. So my first point is that I don't see what rationale there could be for why the accused in these courts should not get any less rights than a person accused under ordinary criminal law in the country. One should start from that principle. So changes must be made to ensure that full rights are provided to the accused. And so while many of these changes are very positive, I would say they're a bit limited. Secondly, I would say that since these crimes are of an international nature, there's good reason to improve on ordinary Bangladesh standards in some respects and follow some international standards. Thirdly, through consideration of what changes that could be made, one, the government should consider, first of all, what was the practice of the courts earlier, and introduce rules to ensure that the unfair practices that happened then can't happen now. So, for example, there was a practice, very common in the ICT, of allowing the prosecution to call as many witnesses as they wanted, but not allowing the defense to call hardly any witnesses. That was not something that was in the rules, it was just a practice that was followed by the tribunal. So that is an example of a practice that needs to be dealt with in some way. And there are other kinds of practices like that that also need to be considered. And the second thing that needs to be taken into consideration are decisions made by the appellate division. There are many decisions that were made by the appellate division that supported unfair practices that are at the moment the law of the country. So consideration needs to be given to that. Next point I want to make is that it's difficult to prosecute an ordinary law enforcement officer for crimes against humanity due to the difficulty in showing all the elements of the offence. So how are these people going to be prosecuted in the ICT? Unless the ICT is to give jurisdiction for the offence of murder, because they cannot ordinarily be prosecuted for the offence of crimes against humanity. So consideration needs to be given to that. In relationship to the particular changes that are being suggested, I think the change to the offence against crimes against humanity, very positive. Introduction of elements of offence, absolutely. Allowing the defence to have international lawyers to represent them, very positive. But it should also be available to the prosecution. And why should the criteria be only, it should be 10 years experience? That does not make any sense. It could easily be reduced to 5 if you want to make sure that the lawyers have some experience of international law. 10 years seems to be too high. As to evidence, I don't understand why technical rules of evidence should not be allowed in this trial. The rules of evidence should be the same as in any other trial in Bangladesh. Or if you don't want to follow ordinary law of Bangladesh, then you should follow the rules of evidence used at the ICC. We are in a situation, as everybody knows, where what happened was seen by many, many people and was videoed by many, many people. We are an evidence-rich environment. There's not a problem about the level of evidence in many cases. So you don't need to limit the threshold for what evidence should be allowed. And then as to the ban on political parties, to me this looks like a sentence simply created to punish the Awami League. I mean, to put it bluntly. It may be popular with other political parties, and there may be a more reason for that. But I think it would be a big mistake for democracy in this country in the future, and it will also not be looked at very positively internationally. I noticed the recommendations are silent on the death penalty. This not only is it wrong on moral grounds, also pragmatically. I think that you will lose international support if you do that. If you allow death penalty to be available for these offences. the investigation and prosecution of these offences needs international assistance, and you will lose that if you allow the death penalty to be available. And I just want to make a comment about interlocutory appeals. I noticed that's absent. I'm not quite sure why those accused under this tribunal should not be able to appeal certain rulings by the tribunal. Thank you very much.